Hi there, I'm Keith Grossman with Grossman Law and Conflict Management. What I wanted to talk with you about today is the different ways that you can proceed in Florida with the dissolution of marriage, a divorce case. So I'm going to run through three major topics. These are the three choices that you really have available to you for being able to proceed with a divorce in Florida. So the first thing that I'm going to talk about is the uncontested divorce. This is basically where you and your spouse, your husband or your wife, are able to agree upon all of the terms within your divorce proceedings. So you can agree upon everything related to how you're going to divide up all of your property. That's your marital property, your assets and your liabilities. You're also able to agree upon everything related to parenting, all the things related to your children, how you're going to spend time with your kids, where they're going to spend their days and their nights, how you're going to handle child support, extracurricular activities, all those types of things related to parenting. So that is something that you're able to agree upon in an uncontested divorce. And then also the financial support. So beyond child support and paying for extracurricular activities, is there going to be alimony or some other type of support that's going to be paid? If you can agree upon all of those things, the division of property, the parenting, the financial support, and anything else that's important to you, then you can do this as an uncontested divorce where you create a settlement agreement and when you have children, a parenting plan. And those documents are going to be created by you together and they're going to be signed by both of you. And you're going to do that before you ever file in court. So you're going to be able to create all of that and then file it in court, letting the judge know when you file that everything's been resolved. So the parenting plan, I want to take a moment and mention that the parenting plan is a document that is required in Florida whenever there's children in a divorce proceeding. We don't have the terms custody or visitation in our laws in Florida anymore. Those went away many, many years ago. But now we are required to create parenting plans, and it covers all of the information related to the children and how those things are going to be handled. Things that I already mentioned, who they're going to stay with, who they're going to spend overnights with, how you're going to share vacation time, all those types of things. So we're going to have a parenting plan as well as a settlement agreement. The settlement agreement is going to incorporate the parenting plan, and all of that, if agreed upon, is part of an uncontested divorce proceeding. So you create those documents, and then what you do is you go ahead and you take them, and there are other documents that need to be filed, but those are the major ones, and you take those and you go to the courthouse and you file it with the clerk's office. And that is how you handle an uncontested divorce. Then you just sit back and you wait. You provide a proposed final judgment of dissolution of marriage, which is the document that says that you're actually divorced. And based on all of the paperwork, the judge can go ahead and sign the final judgment. Now, some jurisdictions require you to actually come and attend a hearing, which is very brief, just to kind of review the documents and make sure that everything's in order. Many jurisdictions, though, allow you to do this typically by filing the paperwork. No need to go back to the courthouse and actually have a hearing. So that depends upon the jurisdiction that you live in. The next thing that I want to talk about is a cooperative divorce or a collaborative divorce. So in Florida, we have a process called collaborative divorce, which has been spreading around the nation and is now available probably in every state at this point. It's a very formal process where the divorcing spouses, the husband and the wife, commit to working out a settlement agreement outside of court before ever filing, but they're not able to do it on their own, so they can't do it uncontested because they can't quite get there on their own, but they need professional help. So they both have attorneys that are trained in the collaborative process. They have other professionals like a mental health professional or a financial professional, could be both. So this team approach to coming to a complete resolution, a complete settlement agreement for all of the things that need to be decided: property, parenting, financial support. So it's this team approach. It's a very formal process. You sign a contract to participate, as well as the professional signing this contract, and you work together in sessions that can be joint sessions with everybody, and sometimes individual sessions with just your attorney or maybe with the mental health professional. So it's a team approach, it's a formal process, and it can be very, very effective, and it can be very efficient, and it helps keep the conflict low for being able to get to a settlement agreement for your divorce. The other process that is similar but has a little bit less formality, and it actually is a few different options, has a few different options available as far as how to proceed, but that's what I call cooperative divorce. So that could be just drafting a settlement proposal and providing it to your spouse. It could be attending mediation before filing and working with a mediator in order to try to come to a settlement agreement. Or it could be that both of you have attorneys and you meet with the attorneys and both of you together, no mediator, no other professionals, but you meet in what are called settlement conferences for the purpose of discussing possible settlement terms for ultimately creating an agreement. So whatever process you decide within cooperative, or if you use the collaborative process, if you are successful in coming to a settlement agreement, then it's just like being an uncontested divorce at that point. You take your settlement agreement, the other documents that you're required to file, you go ahead and you take that to the courthouse and you file it, and you basically wait for the judge to sign a final judgment of dissolution of marriage based on the fact that you've already come to an agreement. You don't need to have a lengthy court hearing or trial, anything like that. The third process is the contested or litigated process, and this is when you absolutely can't get to a complete agreement. Maybe you've tried the others and they haven't been sufficient, hasn't been effective, you haven't been able to get a settlement agreement accomplished, or maybe you went right to a contested or litigated process because you didn't think the others would work, or you just briefly attempted and it went south very quickly, so you decided just to go and file your petition of dissolution of marriage. And that's what happens in the contested or litigated process. You can't agree upon the terms, so one of you has to file a petition for dissolution of marriage, which opens up the case with the courthouse. So now you have a divorce process starting. As you go along, you can try to settle and get to terms that both of you can agree upon to avoid ultimately having a trial with the judge. But if you're unsuccessful in being able to come to a complete settlement through whatever process you attempt to do while it's a contested or litigated case, if you can't get to a complete agreement, then ultimately the judge has to make the decision on those things that you cannot agree upon. So that's the contested or litigated process. Hope this helps, and I hope you found it informative. Look forward to helping you with any questions or concerns that you have. Make it a great day.